Hi guys, I'm Laura, and I want to invite you to watch a special workshop I did recently at Cal State Fullerton, where I'm going to show you everything you need to do to protect your family with a will and trust. So enjoy the workshop and stick around because at the end I'm going to have a special gift just for you. Thanks for watching.
So before I turn everything over to our presenter, Laura, I'd like to go ahead and just introduce her a little bit. Laura Meyer is a California estate planning attorney who's also a proud alumna of Cal State Long Beach, but we do not hold that against her because many of her family members are proud Titans, and we're happy to have her be a part of this. She's been doing these presentations for us now for well over a year, and we'll be doing several more throughout the year. So she knows us very well. Laura is the author of The Family Nest Egg and Good Parents Worry, Great Parents Plan, and host of the If Life Were Perfect podcast. She and her husband, Josh, own the Meier Law firm in Newport Beach, California, and they're the proud parents of 4 children. And Laura will tell you a little bit more about herself. So I'm going to go ahead and stop sharing screen so I can turn it over to Laura. And everyone, thank you so much for joining us. And I will turn it over to Laura.
Great. Well, can you hear me okay, Hart?
Yes, we can hear you. Thank you.
Okay, perfect. Well, it's so good to see you, and thank you so much for having me on these calls. As Hart mentioned, I am the proud daughter of 2 Titans, and I also have 2 siblings who are Titans. So feels like extended family for me being able to be with all of you. And I'm excited today to share information with you that hopefully will get you thinking more about who you love, how you want to plan for them, and also how you can benefit those even beyond your own family. So this is a safe space, as we love to say. This is a time where, if you want to turn your cameras on and interact, I'd love to hear from you, to see you, and to get all of your questions answered. I'm going to go ahead and share my screen with you now so we can, let's see. So here we go. Okay, so hopefully my screen is now maximized for you. But, I am just quickly about me. What we're going to do in this time is I'm going to walk you through, what would happen if something happened to you, kind of California's plan for your family and what you can do about it. And then if you already have an estate plan in place, I'm also going to talk to you about things you might want to think about to make sure that it's up to date and would actually work the way that you would want. This is a picture of who I'm planning for right there. Those are my 4 kids, and they're much bigger now, but of course I didn't want to change the photo because I'm not, 37 and not like I was in that photo. But those are the kids. The oldest just turned 18. And my husband, Josh, he's an estate planning lawyer too. He's done these calls with CSUF as well. And really, as beyond just our practice of helping our clients, we really speak a lot in the community to try and help our fellow neighbors to make sure that they can go confidently in life, knowing that everyone they love and everything they've worked so hard for is protected. Those are just some of the outside projects I've worked on. Hart, he wants to make sure that he's bringing in reputable people, which I appreciate. So I've proven to him I've written 2 books, one of which was endorsed by Barbara Corcoran from Shark Tank. So that was a fun surprise and got me bonus points in the eyes of my children. And Josh and I also have our podcast. I think though what is most noteworthy on this though is we work with wonderful families in the community, and we're blessed to be a 5-star business. So that's everything about us, and I know you're here for you, so we're going to get right to it. What percentage of Californians do you think have an estate plan? And if you could go ahead and put your guess in the chat box, it's really fun to see what everybody thinks. And don't worry, we don't shame anybody. So if anyone wants to take a guess of what percentage of Californians have an estate plan, and we'll see what we think. Okay, 20%, Tony says 10, Melissa, it's going so fast. Okay, 25, Mark says 5%, Tim, 10%, love it. Laura Bell, 15, Margie, 10, good guesses. CC is saying 25, Pia 10. So a lot of the same, yeah, kind of in the same ranges here. Nobody's guessing 90% or anything like that. So that's good. And Noel, we always have someone who doesn't have as much confidence in us fellow Californians. Noel's coming in at 5%. So I love it. Okay. So it was kind of a trick question, but the answer is actually 100%, and your family included, which means 100% of Californians actually do have an estate plan. And if you're confused, the reason it's 100% is because if you haven't taken time to legally formalize your wishes for what should happen if you become incapacitated or pass away, the state of California will step in for you with their own plan for your family. And as a spoiler alert, you are not going to like it. So this is California's default plan for your family, and this is what we'll be talking about today. If you have minor children, they can be placed in temporary foster care, and a judge would have to choose a guardian. And sometimes people go, oh, finally, I'm in the clear. I don't have to worry about it. Well, if you're a grandparent or you're an auntie or uncle or anything, that is something that you'll want to think about. Probate court, something that for your assets to go to someone else when you don't have planning, your assets would have to go through probate court. You have no control over the distribution of your wealth. You can have an estate tax issue, a medical nightmare, and a lost legacy. So let's take a deeper look. And I always want to be encouraging on these calls. You will have options if you don't like these things, so you don't have to worry about it. We have our first question from Laura, which is such a good question. She's asking if this webinar is only for residents of California. And you know what, while every state's different, most default laws are modeled after our federal rules. And so you'll get a lot out of this if you're not in California. However, you will want to always, even if you're here in California, consult with an attorney for specific legal advice of what would happen in your state. But Laura, I will be using California as a frame of reference. And the good news is if you're not in California, Laura, your state does it way more efficient because we are the most inefficient probate court process in California. Okay. Now, we're going to briefly touch on guardianship, but obviously, if you are a parent of a child who's under 18 and something happens to you, your children can be placed in temporary foster care, and a judge who doesn't know your children would have to choose a guardian. Not what parents want to hear. So there was actually a family in San Diego a few years ago where the husband and wife were killed in a car accident. And instead of those children being placed in the care of their family members, they were immediately placed in the care of strangers. And then for over a year, the aunts battled in court over who should be the guardian. And they were ultimately placed in a family that was completely torn apart. And that's something that we would never want for any child, especially our own child. And it's also something that's avoidable. So the way to opt out of California's default plan when it comes to your kids is you need to complete the appropriate legal documents to name permanent guardians for your children. That's typically done through a will in California, although there is a standalone form where you can do it. And that's where you're going to designate a first choice, a second choice, and even a third choice possibly to name you, to raise your children if something happens to you and you pass away. What happens though is a lot of people will, who go through the trouble to do estate planning, they will name a guardian. However, they don't think about the short term. So they might say, well, I named a guardian in our will, but they don't think, well, if you really were in an accident, is someone actually going to go get your will and on the spot pull it up and say, oh, the grandparents are supposed to be the guardians? That doesn't happen. There's usually a gap period between when someone gets hurt and somebody finds documents. And really, you guys, this applies to all your documents. There's a gap period usually, which needs to be addressed. So with guardianship, we tell parents to also consider the short term. And so really every parent should have a full kids emergency plan that really addresses who should be called in an emergency and that those people have authority to actually keep the children so they're not placed in temporary foster care. So you will want to complete legal documentation that names temporary guardians to care for your kids until the permanent guardians can be safely take custody of them. We recommend that this be people who live in the immediate area, especially if your permanent guardians live far away and need to travel. You can pick family in the area, or you could pick friends, neighbors, anyone that could keep your kids safely until a permanent guardian can arrive. We also want parents to have cards in their wallets, so first responders would know how to get in touch with these temporary guardians who have this documentation. And along with that, parents can fill out instructions to their caregivers and guardians about how they want their kids to be raised and what family members they want to remain in their life, especially if there's ever been a divorce situation. It's very important that, as the parent say, I do want my children, I understand they might go with the other parent, but I do want my parents to be able to continue to have a relationship and those things, to express your wishes for your children's future. And then to document your children's healthcare history. The last thing, which is so important now too, is to make sure your children have a medical directive so that their medical decisions could be made if you're all hurt. It used to be growing up, parents would sign that little form where anyone could treat their child. Well, now thanks to lawyers, said with love to my colleagues, you have to have everything so official now. So we do want to make sure that they have forms that a true medical directive so decisions can be made. So that's what a good kids emergency plan looks like. And if you're relieved that your kids are over 18, if you have any children who are between, I'd say 18 to 25, it is so important that you have them complete their own medical directives so you can continue to help them make decisions in an emergency. So many horror stories where students get hurt when they're away at school, and the campus, I'll just say it on behalf of CSUF, they would love if any student had a medical directive. They want to step in and help your kids. They want to treat them, and they want you to be able to help. But without that authority, they're not authorized to, share stuff like that. And so we need to make sure your kids are safe and protected. So please do make sure that they complete medical directives as well. My son, who turned 18, part of his birthday gift, of course, having a mom as an estate planning attorney, is he got to come in the next day and sign medical directives so we can make sure we could continue to help him. And I was very honored he picked me. He probably felt pressured, but anyway, he did pick my husband and I to make the decisions, and grandparents as the backup. So anyway, it's something I do encourage to all of you. Now, let's move on. We talked about kids. If anyone has any questions before we move on what you need to do to opt out of California's default plan for your family when it comes to kids, can ask them. Otherwise, we're going to move on now to something that certainly affects all of us, which is not a fun topic, but very important. So in California and in other states as well, many of them, if you pass away, in order to get your money to someone else, if you haven't done your own method of planning, your family will have to go through a very long and expensive court process known as probate. Now, I always say probate is not like Starbucks where you just come in and get in your order and go. Imagine 2 to 3 years of paperwork, kickbacks, delays, frustration. That is what probate court is. And it's something that it's even longer. It used to be shorter, but even with COVID, when the courts were shut down, it was so long. The other thing is it's open and public. So that's why when a celebrity dies without estate planning, we're all front and center reading TMZ to find out all their business because it's public record. There's no privacy when you go through probate court. It's also a platform that just naturally creates animosity and frustration. So you could take a perfectly good family and siblings who want to work together and end up just fighting in court. And sometimes we do probates as well here. And so sometimes I have to tell them, you guys, you're not really fighting with each other. You're just frustrated because you're having to fight a court process. And that's the reality, is it's just the perfect platform to air disputes. Especially if you have minor children at all, their money actually doesn't even come out of probate at the end. It gets placed in these supervised accounts, so the probate nightmare can continue for years. I had a father once we represented who the poor guy, his wife had left him. She ended up passing away, and he had to be in charge of her entire estate. And then every other year he would go for his kids to do the accountings. And ultimately the money came outright when they were 18 with no restrictions or protections. By the way, he was such a sweet guy. He never had a dime paid for it out of the mother's estate. He was such a sweet man. He paid for it for his kids, but it was a nightmare, and that's something we wouldn't want. So you're probably thinking, this is a nightmare, I wouldn't want it, and probably this is, though, the cheapest route to go. Probate is the most expensive form of estate planning, the most expensive way to do it. If you have a bad trust, if you have an out-of-date trust, or you never did an estate plan at all, you're going to end up in probate, and you're going to pay top dollar for it. You might as well just burn money now to see how much it's going to cost. This is an example of what probate costs in places like California. Outside California, it's not going to be as bad usually, but you could probably just Google what probate fees are in your state, because it's set usually by the probate code for that state. It's not something attorneys make up. It's all set by the code. So in California, it's going to start out, it's a chart. It starts out where they'll take 8% of your assets to pay for the process based on the total estate worth. As you go up into the millions, if your estate value is, the higher it is, the less percentage they take. So they're not totally gouging these larger estates. But it's calculated based on the fair market value of your assets at the date of death. And it does not take into account your debts or liabilities. So if you have a home that is worth $3 million, if you sold it today, but you have a mortgage on it that's $2 million, fees will be calculated based on the $3 million. So you can see why in places like Orange County it gets very expensive. So in this example, I put the home at $500,000, which is incredibly low. We all know you can't get a home here for that. But here, $500,000, bank accounts are 20, retirement is 100, life insurance $1 million, personal belongings 25. This estate estate was worth 1.6 million, and they're using a more conservative figure of not the 8%, but a 5%. It's, $82,000. This is just an estimate and an example. It's not an exact. You would be able to find out what probate would cost by consulting with an attorney, but this is to give you an idea of how shocking it is, the fees. And I can tell you, as a firm that does probates, we see probates cost even more, just simply because of the home values here. Now, I put an asterisk next to retirement account and life insurance policies. That's because you'll recall when you got your retirement account or your life insurance policy, they asked you if you wanted to name a beneficiary, and you probably wrote one down. And that's great. So as long as that person's living and they're over 18, the money can be paid out and it can avoid having to go through probate. However, we put the asterisk because sometimes people don't, that person's not living, like they predeceased that the person who died, or they named a minor child who can't just receive the funds without court supervision. So that's why I put that there. However, I have found that usually by the time kids are raised, or if people are child free, they usually have this, an estate well into the, millions, especially with the home values here when they pass away. So this should give everyone kind of an accurate figure. So not fun, right? And you're, probably thinking, how can I avoid probate? I only had one client once who came in for a consultation, and he was so upset with his adult children. He said, I want them to go through probate. And I thought, wow, like the holidays must be fun at your house. But most people would never want their family to end up in probate. I have to help people even when they didn't have planning, but it is so hard to have to watch families go through this process. And we can give them as much TLC as possible, but the process is the process. It's not fun. So how can you avoid probate? It's actually very simple and very cost effective. And that's by creating what's called a revocable living trust. Now, a lot of times people hear the word trust and they think it's for wealthy people. But really, the standard to go through probate is you either have to own property that's worth more than $50,000, or you have more than $155,000 of assets that need to get passed that didn't pass through beneficiary designation. So almost everyone here is subject to probate in California. So that's why the solution is for everyone. And you might not all need the same comprehensive type of trust, but everybody needs some type of revocable living trust. And basically what it is, it's a legal document your attorney can help you create that says, this is who I am. This is who I love. This is how I want my money to go to these people and on what terms and with what protections. And this is who I would like to be in charge of carrying it all out so a judge doesn't have to step in. Now, a common question people will ask is, well, what about a will? Can't you do this with a will too? And people are shocked when I tell them that a will in California does not avoid probate court. It doesn't avoid the whole process of probate. It does say where you want your assets to go, which is good. It's not just going to be next of kin, but it doesn't avoid it having to go before a judge, and it certainly doesn't avoid those fees I talked about. Only a trust can do that. And so when you set up your trust, what's nice about it is you're going to have the option of how you want to pass money to, if you're married, or to children, or to charities, whoever you're benefiting. Now, even if you already have a trust, you're really going to want to really pay attention to this part, because a lot of clients who come to me, they do already have a trust. They set them up when I was probably in high school or whatever, and they're coming in to redo them. And a lot of times they didn't realize that they had options with how they pass the money to other people. And if you do have a trust already and you did it in the 90s or 2000s, and it was the last time you updated it, you have to go to your estate planning lawyer right away, because during that time, there was a trust structure in it where money had to, I don't want to confuse you, but you got locked into a bad tax structure. And there was a reason for doing it at that time, but now there's a better way. So it was called a mandatory A-B split. If you have that, you really do want to update your trust. So Melissa, I know it was the early 2000s, of what year in the 2000s, but I will tell you, generally speaking, you should be reviewing your trust every 3 years. And so if you did it anytime in the 2000s, you're likely locked into the A-B split. Okay, so let's talk about what your options are today to either update your trust structure, or if you've never even had a trust, what you can do. You can, and I'm going to use a married couple as an example with children. Certainly, if you are single and your beneficiaries, we can talk about that too. So in this case, Mike and Sarah are married, and let's say they hold their assets together up in their family trust while they're living. So their home, their bank account, whatever it is, their investment accounts, it's theirs. Now, when one spouse dies, and I joke, I kill the husband off first because it's less emotional. Just kidding. My husband hates that joke. But anyway, so if Mike passes away, at that point, the money splits in two, right? Because you had Mike's half and Sarah's half. Mike has a choice when he's setting up his estate plan. He can say, look, when I die, my half is just going to go over to Sarah. She can do whatever she wants with it. It's 100% hers. If she wants to get remarried and put all the money with a new spouse, she can do that. If she gets sued in a car accident, it's her money. It's going to get taken. There's no protection. And if she decides she doesn't want to ultimately leave the money to our kids, she retains the right to give it all to somebody else. And some couples like that. They're like, we've been married forever. We don't have a history of divorce in our family. We're not worried about that. We're not in professions where we're going to be sued. It's simple, it's easy, it's straightforward, done. And so sometimes that's a great option. Well, for other people, it might not be the best option. So the other option, which is very popular, is the legal term is the Clayton election. But what it is, it's basically when Mike passes away, he says, look, Sarah, I love you, I trust you. And Sarah, you can do, of course, whatever you want with your half of the money because she's still living. But Mike says, and Sarah, you can use all my money, everything you need for your health, maintenance, education, support for the kids. My money is your money. But Sarah, if you are getting remarried to somebody else, in order to keep using my money, you must sign a prenuptial agreement with that spouse. And you have to agree that my money is not his money. And that my money ultimately can only go to the children we plan for together. So if you go and have more children or you have stepchildren, you can give them your share, but for my share, since I'm gone, it's only going to the kids I had and I planned for. Plus, Sarah, let's say she's a doctor. Sarah, if you get sued at work, I understand they can go after your money, but because it's over here in my trust, then you're just the beneficiary of it. They can't go after my money. There's an extra layer of protection. So that's very popular because it allows, for the surviving spouse to really have full control over all the money, but to have protections over the late spouse's money. So it's not going to go to ill-intentioned third parties. It's really going to go to who that spouse planned for. So if you have questions on that, you can ask in the chat. And it's also nice. It's nice for blended families if they want to make sure their children from prior marriages are planned for, things like that. It's very nice if you're a business owner or you're in a profession where you could be sued and you want the asset protection. So there are reasons why people really like that. Laura asked what the term is for that. It's the Clayton election. It's named after a court case, a guy named Clayton. So it's Clayton. And I will, at the end, I'll give you all a free gift that will, you'll be able to read up more on this information. Now, let's talk about the kids. It's the same concept. You can pass money to your kids and say, look, once you hit age 30, for example, if mom and dad are gone, the money goes to you and you get it when you're 30. That's kind of the old school structure, and that's a good structure for many people. However, some people say, well, gosh, I want to make sure that, if I pass away, the money goes to my child and can't be taken by any ill-intentioned third parties. So if my child ends up going through a divorce, or there's a creditor or predator lawsuit, kind of what we talked about in the other example, that money would be safeguarded for their children's lifetime and ultimately go to the next generation with the same protections. So that's called a lifetime asset protection trust. That's an option when you set up your estate plan to pass the money to your children with those safeguards and protections in that structure. Now, in this example, I made the family the beneficiary, but keep in mind, many of the families that, in our community, they do benefit their parent, their spouse, their children, and all of that, but they also benefit others. They might be financially supporting a parent, for example, and they want to make sure money's also set aside for them. Or they might have a charitable cause that's very important to them, and they want to leave some money towards that. Or maybe they don't have children, they're child-free, or whatever the situation is. What's beautiful about a trust, unlike probate court, is you create who you want your beneficiaries to be and all of that. Now, you can't disinherit your spouse if there's a legal arrangement there, but you'll talk to an attorney about that. But for the most part, your children, they don't have a right to inherit from you. It's not their birthright or their legal right. You really do get to choose who benefits. And so just setting up a trust is a wonderful way to really think about who you want to benefit and how you want to benefit them. And just to know these strategies are available so that you could pass money to who you want with the most responsible methods and ways. Okay. So do you know why the number one reason why trusts fail? Does anyone want to take a guess in the chat box? Why a trust might fail? Everybody's shy? I would actually joke it's because one was never created. That's probably the most popular reason it doesn't work, since 70% of people don't have estate planning in place. But no, actually the number one reason a trust fails is because the family assets were not properly connected to their trust. So when you set up a trust and sign those legal documents, you actually then need to go through your accounts, your home, and all of these things, and you either need to retitle them in the name of your trust, or you need to name the trust as a beneficiary. Your attorney can help you understand how to do that and how it should, an asset should be owned. But so many people, they set up a trust, they take the time to do it, and then they don't go and change any of the accounts, and their family still ends up in probate. And, you know, there's kind of a, in the legal profession, I joke that I think a lot of estate planning attorneys do that. They don't make it part of their process to fund the trust, because then they can get the probate once the plan they set up doesn't work. But I will tell you, it's so important to make sure that you're continually updating your trust with your assets. And so every year, at the end of the year, I like to just go through my assets and make sure that they didn't inadvertently come out of the trust. If you refied your home, for example, at any point, there's a good chance your lender didn't put it back in the trust after their refinance. So you're going to want to pull the deed, right? You should do it this week. Actually, you should either ask your attorney, or you could do it yourself. It's a public record, but pull the deed and make sure that it's owned by your trust if you have one. So that is very important, is to make sure it's connected. We have a couple questions that I just want to hit real quick. Yeah, trust funding, Laura Bell, that's trust funding. Mary says, is a will even necessary if you create a revocable living trust? Yes. So when you set up your estate plan, your attorney you'll create a revocable living trust. You will also create what's called a pour over will. It's like a shortened will. And what that does is, that's where you might name guardians if you have kids, but it's also where you will make a statement that says, I want all of my assets to go to my trust. So on the off chance you didn't, that's a document we use to go into court after someone dies and say, Your Honor, they wanted everything to go in their trust, so we need that, bank account to come over. It doesn't avoid us having to go through a judge, the time that's spent, the delays, and the money, but it's like a safety net we use. So Mary, you would need both, a revocable living trust and a will. One of our fellow Titans also asked, does each spouse need to create a trust, or can it be a joint trust? So usually it's a joint trust if it's holding joint assets that you had together. Sometimes people have multiple trusts. So for example, let's say I owned a home before I got married. My husband owned a home before we got married. Then when we got married, we bought a home together. We might want, if we want those homes to remain our separate property, and it basically is if we're worried there was ever a divorce and we don't want to gift it to each other. We would have separate trusts to hold our separate assets, and then we would have a joint trust to hold our joint home and any joint accounts. So depending on your situation, you might need a joint, you might need separate. Some couples don't own anything jointly. Especially if it's a second marriage later in life, they just have separate estate plans because they don't actually own joint assets that they've commingled. Nancy asked, how does that affect the name on an IRA? So I can't give specific advice, but I will say that our IRA accounts are always owned by the individual person. A trust cannot own an IRA account, so a revocable trust. So it would affect the beneficiary potentially of your retirement account, and you would need, depending on how you structured your trust, the trust might need conduit language provisions. See, now I'm giving legal advice, but we need to make sure your trust is even robust enough to be named as the beneficiary. So consult with your attorney about that, if your trust should be the beneficiary. I will tell you for my clients, simply because we have very robust trusts and stuff, that usually somewhere in the beneficiary section designation appears the trust at some point. Okay. Now moving forward, estate taxes, so we talked about guardianship, probate court, and no control over distribution of wealth when you don't have an estate plan, and how you can name guardians, have a short-term plan, avoid probate court with a revocable trust, and also asset protection for the spouse and kids and things like that. Now we're going to talk about estate taxes. And the good news is actually that you can pass up to, and I've, up to, as an individual, over $11 million to somebody else without them having to pay any estate taxes. So it's not taxed. That inheritance is not taxed unless it's over 11 million. If you're a married couple, it's over 22 million that you can pass. Now, those are the rules until the end of 2025. I don't know what the rules will be after that. They haven't said or determined it. Last year during Build Back Better, when they were trying to pass that legislation, they were talking about lowering the estate tax exemption down to 3 million per person. And there was also a time in the 90s where it was 600,000. So it's been different levels. So I don't know what it's going to be in 2025. I definitely don't know when it's going to be when you pass away. So you'll want to plan accordingly. But right now it's pretty high. There's other taxes, though, when you set up your estate plan that you'll want to think about because, for example, homes now, when someone passes away, will now get a property tax reassessment. That's a change that happened last year. Stuff like that. There could be capital gains taxes on certain assets when you pass away. And so those are all things that you do want to talk about with your estate planning attorney and have on your radar. But generally speaking, right now, from an estate tax standpoint, you can pass a lot and not worry about it. Now, the way people traditionally have reduced estate taxes is they have done charitable giving. They have set up foundations or they've made large donations to places like Cal State University Fullerton. And it's kind of a great thing because they're saying, look, instead of paying taxes to the government, I'd rather instead give this legacy gift. And the government will say, great, we're really glad you're giving money to Fullerton, and now we're not going to make you pay us as much when you die. That's typically how we reduce taxes. Similar to how right now when we're living, we can write off charitable deductions and things like that. So that is definitely something that you're going to want to think about. But what I want to talk about just real quick is, from an estate planning perspective, is you please don't wait until you're a massive millionaire to think about benefiting people beyond your own inner circle. Even I sit with clients who have $50 million and they're so worried that their two kids, that they can't give money anywhere else, that their two kids need it. And those are personal decisions and I don't judge that, but I will tell you it's a beautiful legacy for the entire family when someone does pass away and those two kids get to go to somewhere like Cal State University Fullerton and sit with the students who benefited from their parents' gift, or to carry on that legacy. And one of the things I do want to mention with CSUF, and this is objective because Hart said I'm not even a Titan, but I'm going to make my pitch. They have some really cool campaigns that they're doing. And if you haven't had a chance to come on campus and see, they just did a huge first ever comprehensive campaign where people left legacy gifts to them. And they got over 76 million in estate and plan gifts. And I know that seems like a large amount, but compared to the need that they have for this next generation that's going to take over, for the entire community, there are future doctors, lawyers, workers, everything, entrepreneurs. That's who's at Cal State Fullerton. That's who you're pouring your resources into. So, that's something to think about with your estate planning is there room to leave something to these kids in these initiatives? They also did these amazing capital projects. So I think this sounds neat, Hart. Maybe you could give me a tour, but they did a total renovation of, McCarthy Hall. They completed a new campus gateway. They renovated several floors on the library. And then the state actually chipped in. That's nice. They're doing a whole engineering innovation complex in the next few years. These are all things that you can be part of, and you don't need to wait until you die. In fact, I hope that you don't. I hope that today, when this is over, you could think about something that Fullerton did for you, or that a cause you care about there, and ask, how can I get involved? How can I make a gift? How can I be part of something, bigger than myself? And, we just at my law firm hired a dedicated plan giving specialist, an attorney, to help clients think through how to give, where to make an impact, where to make a difference. It is something that, is important for all of us to really think about. So hopefully those are some ideas, but think about, if you did have extra money now or at the end of your lifetime, where do you want to leave your legacy? How can Cal State Fullerton be part of that? And I'm sure Hart would invite you to talk with him directly. Hart is the most low pressure plan giving person I have ever met with. He will not pressure you. He'll be excited for you, and he will find a perfect way for you to make an impact. So you will be in great hands if you talk to Hart. And if you are very wealthy, it will save you a boatload of taxes. We'll leave it at that. Okay. Now, I want to talk about medical nightmare, all right? California's default plan. I used to do this slide before COVID, and I'd say, yeah, it's a medical nightmare if you don't have your directives. And after going through COVID and getting the phone calls from family members who were shut out from the hospital, who couldn't be with their loved one who died in the hospital. And it wasn't even from COVID. They had to go to the hospital for something else, and family couldn't be there. Nobody even had COVID. It was devastating to get these calls, you guys. And you probably know from watching the news, how many doctors did they show on CNN or Fox coming out crying, saying, I wish people would get their directives. I remember on Good Morning America, a doctor went on and said, please, my entire unit is full of dying COVID patients and not one of them has a directive. The hospitals, they want to save your loved one's life. They do not want to have to make those discretionary decisions about what your loved one may have wanted or what you think is best for the person you love. So we strongly encourage you, on behalf of all my colleagues in the estate planning community, please, please, please have prepared medical directives. In this case, even with some hospitals still shut down to outside visitors, it really is your only voice you have when you're in there about what your wishes are and who you would want to make decisions if you can't make them for yourself. So what medical directives are, there's 3 components. Sometimes it's in one form, sometimes it's in 3 different forms, but it covers 3 different things. And it talks about who should get medical information on you. Because under HIPAA, it's private, right? I can't call up, Tony's doctor and ask about her health report. She can't call up mine, right? They're going to say, who are you? No, you're not authorized. But certainly I would want my mom to be able to find out what's wrong with me if I'm in the hospital. So she's on my HIPAA authorization as someone I want my information shared with. You also need to address your end of life wishes. Do you want to be brought back to life if you've basically died? Do you want to be kept on artificial life support if you're not going to recover? What do you want? And then the third is, who are you trusting to make these decisions? Who's that person that's going to advocate for you, not just an end of life, but if you need to be put in a home, if you need medical treatment, care, anything like that, that's who you need to have listed on your medical directive. And I didn't mention this earlier when we talked about who should be in charge of your trust, but I'll mention it now. In general, we do not like when you list 2 co-decision makers, because that is always ends up in a fight. There's even a couple who loves each other deeply. Is not always on the same page. One wants pizza, one wants a burger that night. There's a fight. Imagine when they're under intense medical situations. So we do recommend that you pick one person and then you have backups, and try and pick the person that will follow your wishes and do the best job and be the least emotional. The other thing is, what's nice about this is when you have your directive, your family's not going to be forced to run into court to get a conservatorship, which is basically saying, look, my family member can't make medical decisions anymore. This is a more permanent thing. I need to be able to make them. that's not something that we never want you to have to run into court for permission on anything. So have your directives. And as a practical tip, when you go in for a surgery or something like that, take a copy with you and with a manila envelope. Even if the hospital already has it on file, take it with you on your chest that says my medical directives, and take it with you in the hospital so you have a copy. Also, please make sure that whoever you've listed to make those decisions has a copy of the medical directives or knows how to access them in an emergency. If they're locked up in a safety deposit box, that's not helpful to anyone. Too many people take the time to get medical directives and then they're not even accessible. You also should file a copy with your primary care physician. And I also encourage you to file a copy with your local hospital that you would go to. So that's how we make sure that medical directives would actually work when you need them to. In addition to that, we also want you to have a financial durable power of attorney so that if you are incapacitated, especially long-term, that someone you trust can make your financial decisions for you. They can open your mail, pay your bills, make sure that you have everything you need from a financial standpoint. Some of our clients, once they get very elderly, they are like over it and they want one where even though they have capacity, they'll sign them just to have their son or daughter or a trusted friend make their decision so they don't have to manage it anymore. So there's lots of options there. I would just encourage though everybody to have one. And if you have an aging parent, by the way, please make sure that they have this. You don't want to wait until anyone is to the point where they are so vulnerable having to do any of this. You want it to be made when there's clarity and there's not emotions and not pressure. So please be prepared. Make sure that you have them and make sure that your parents have one. And then going back to the young adult children, make sure they have one, and so that while they're at college that you can help manage the bank account and things like that, especially in an emergency. Now, we've talked about a lot of things: guardianship, probate court, why we need to have a trust, control over your assets so it doesn't go to next of kin. Talked about reducing taxes and charitable giving, and we talked about medical nightmare. Now I want to talk about, as we wrap up, and ask, do you know what the most priceless asset of all is? Actually, as you think about that, let me answer these questions real quick. Can the property tax reassessment be avoided with a trust? Laura, I can't answer that directly. It's too specific. And then Maria, does the mandatory AB refer to the assets going fully to the spouse? The mandatory AB split is actually, it divided the assets, it made it mandatory to divide the assets. And so some people liked that from the standpoint of the control I talked about, but it provided no flexibility. The Clayton election is the modern twist on the AB trust. So you kind of get the best of all worlds. You can get the asset protection, but also have a lot of tax flexibility and stuff like that. Okay, so going back to the most priceless asset of all, does anybody want to take a guess on what is the most priceless asset of all, of everything we've talked about? Anybody? Okay, well, I will answer it for you. And you're gonna like the answer, I hope. It's you. You are the most priceless asset of all when it comes to your estate planning. You are the person that your friends and family will deeply miss. You are the person that people will want to remember. You are the person that they will long to hear your voice, that they will celebrate you, and they will not forget you. So I still remember running into a gal who lost her mom, and she inherited a lot from her mom. And I said, how are you doing? And she didn't say, I'm really enjoying that vacation house I got. She said, I miss my mom so much. I just wish I could hear her voice. I just wish I could talk to her. You know, and the reality is, like, we as estate planners, we stress so much, like, please do your planning and all of this. But at the same time, take time to preserve what matters most. So one of the things that we do and we encourage you to do is a legacy interview. That's where you talk on audio or video to your loved ones and tell them that you love them. I will tell you, sometimes people will say, you know what? My kids are grown. They've heard this a million times. They don't need to hear this anymore. Well, guess what? Do you know how many people I sit with who say, gosh, I wish more than anything that my kids could have met my mom or they could talk to my dad. You know, we don't know how long we're going to be here, and we don't know the full extent of future generations that will miss us or whoever it is. So take time to preserve that and to say, I love you one last time. It's a powerful thing that you could do, and it is one of the greatest gifts that you can leave your family. So let's do a recap of your current plan, okay? If you don't have a plan at all, you're at risk of your children, minor children, being placed in temporary foster care and a judge choosing guardians. Your family would have to go through a long and expensive court process called probate that could cost tens of thousands of dollars, if not more. You have no control over the distribution of your wealth. It just goes to next of kin and outright without any restrictions or protections. So even if you have an 18-year-old, they get all the money. Estate taxes we're not worried about, but you know, you're not able to benefit anyone else other than next of kin when you don't have a plan. A medical nightmare full of frustration and heartbreak for your family that leaves you at risk if you don't have the proper authorizations in place, and the lost legacy. Even if you have a plan, again, if any of these areas are not fully updated and brought up to current law, or maybe the people you picked made sense 10 years ago and now that they don't, or maybe you're worried that your son has now become a doctor and he's at risk of lawsuits, your plan needs to be up to date. And you also need to make sure all your assets were properly connected. So without that, you are also at risk. The good news is you really do have the power to change everything. Nobody is forcing you to stay stuck without a plan or with an outdated plan. That's entirely within your power and control. And an ideal estate plan means that your kids have a full kids emergency plan with guardians named. You have a revocable living trust that says who should get your money and on what terms and with what protections. You can have asset protection so money can stay in the family and not be inadvertently taken by ill-intentioned third parties. You can create a legacy and be part of something while you're living and after you go that will impact people forever. You can have full medical and incapacity care. So if something does happen, your family's not trying to go having to run into court. They're by your bedside or they're helping monitor things for you so you're safe and protected. And you can preserve your legacy where even when you're gone, your family can still hear your voice expressing your love for them and preserving special memories. Now, it's easy to know that if you don't have an estate plan, you absolutely need one. What gets confusing is if you have an estate plan and you wonder, well, is it good enough? Or how do I really know if I should update? So as lawyers love to do, I will answer a question with a question. But my question for you is, if something happened to you today, could you take your estate plan and hand it over to your family and say, don't worry, I took care of it, all is well? Do you have that confidence where you can make that promise? And I think for most of us, the answer is no. We probably need to revisit things and tighten up and button everything up. All right, so the two big questions I'm going to answer, because everyone used to ask them on the call, so now they're part of the presentation. I'm going to answer them now. Let me just ask. Kyle wants to ask, who benefits? Why is probate so expensive in California? And who is the one who benefits the most from it? Well, probate involves paying judges, bailiffs, paperwork, lawyers, people, all sorts of things. So people have to be paid. So I don't necessarily think it's that California is trying to profit off of it. It's just such a huge process when you're going through any type of court process. It's expensive. But that's a good question for a legislator to ask, probably about all your taxes. I'll talk about average cost of estate plan. And then Mary says, is the first step in creating a revocable living trust to make a master list of all your assets, then find an estate planning attorney. That's up to you, but if a good estate planning attorney is going to have you do that as a first step when you work with them. I know at our firm, we have a family wealth inventory spreadsheet that people immediately fill out to gather them. So that's up to you in what order you do it in. And then Bill says, when will recording this tremendous presentation be available? Thank you, Bill. I'd like to make it available to all 5 of my siblings. Hart, I believe you will send out Hart will send out a link, Bill, for your siblings to review this or view this, and you can review it. Okay, so as we wrap up, the 2 big questions everyone asks. One is, do you need to work with an attorney? And I'm going to tell you, not everybody does. And that is the truth. You really only need to work with an attorney if you own more than just personal belongings. So if you're renting and you don't have assets that are really more than like $155,000, you might just need some power of attorneys and things like that. And you could probably spend the time and figure out how to get some things, but you probably don't need to be working with an attorney. But if you own more than personal belongings, like you own a home or you have more than $155,000 in assets, you really should be, or you have minor children or anyone who financially depends on you, you should be working with an attorney. You also should work with an attorney if you just want the ease of knowing your money will pass on without going through the court process. Because again, if you download a will, your family's going to end up in probate anyway. Also, if you want the confidence of knowing that your plan was prepared by someone with a fiduciary duty to act in your best interest and do it right, and who's accountable to your family, you want to work with an attorney. There's a reason why all the online drafting softwares will say a huge disclaimer like, hey, we're not lawyers. This stuff doesn't work. Ask a lawyer for something real, but we'll gladly accept your $100. You will want to work with an attorney if you want that confidence that your plan was actually done correctly. 2, you'll want to work with an attorney to make sure your plan stays up to date. So please don't go to a document mill that just gives out forms that you could give online. That's not a relationship. You're going to want someone that you can go to make updates, who knows your family, that you can, when you buy a new property, you could call them up and say, hey, anything special I need to do? Your life will change, and you need to have a relationship with an attorney who's going to be able to be there for you, not just today, but for the years to come. And then the biggest thing is you're going to want to work with an attorney if you want your family to have someone to turn to in their time of need. Yes, your friends will bring you a meal train, and your attorney might even bake a lasagna for you as well. But your attorney is the one with the legal knowledge. They're the ones who are going to know exactly what to do and when and how. And so you will want to establish a relationship with an attorney who you will be able to turn to. And, on that note, I would be leery of an estate planning attorney where it's a solo person who just does it all and even answers their own phone, because what happens to you if something happens to them? What happens if they're retired, died, quit, or whatever it is? You want to make sure you're working with an attorney at an established firm who has other people who could step in if something happens to your attorney. I'll tell you, we absorbed a lot of work during COVID because attorneys just retired or they died. And so that left people just in scrambles because they had to totally restart, to make sure that they're not in that position again. So those are things to think about if you want to work with an attorney. And then also the cost. What should this cost? Well, we know what it costs not to plan. It could cost $100,000. But really, beyond just the cost, it's the time. It will cost your family 2 to 3 years of heartache. And it will also cost you, sadly, your reputation, because nobody wants to be remembered as the person who left their family with a big mess on their hands. It's just not. It's so important that we meet our moral obligations to our loved ones. So there's a lot it costs to not plan. Now, to set up a plan, if you call firms, they'll give you a wide range. You'll hear everything from $1,500 to $10,000, all sorts of stuff. So rather than when you call up a firm and says, what does it cost? I encourage you to first ask, what do I actually need? And what do your services include? That's the only way to objectively evaluate if you're getting what you need and it's a fair cost. Most reputable firms now will charge between $5,500 to $7,500 for like a full setup. Ask them if they do payment plans, ask them what that includes, ask them if they have asset protection options, all of those things, so that you can make sure you're getting the right value. Check out Google, check out Yelp on firms, see what other people feel about the value that they paid and what they got in return. I hope you enjoyed the workshop and that you learned a lot. I want to invite you to click on the link below so you can grab your time to talk with us directly about what type of estate plan you might need for your family. We'll listen to you, we'll give you guidance, and we'll make sure you're completely taken care of. So go ahead and click on the link. Plus, we have special gifts in there waiting for you. Thanks again for watching.